And now it's time for one of our more positive segments, Tips for Good. So Nathan, why do we do Tips for Good every week?
Well, because the other day I was making a milkshake, and then I looked outside and I realized there were a bunch of boys in my yard, and I was thinking, damn, my milkshakes bring all the boys to the yard. And I just got to say, it's better than yours.
Yeah, that makes sense. And you know, milkshakes make the world a better place.
They do, and so do tips.
Oh, there we go.
Boom!
Excellent.
So, Michael, what is our tip for good this week?
Our tip for good this week is to get a flu shot. It's another pretty tactical tip, but it's one that we wanted to make sure to bring up because it is a weird time of year. It is a weird year in general. And as we've seen so many times with COVID, good habits tend to be eroded during the unexpected. And so we want to make sure that even though there is this super pandemic out there, we're still doing the basic things we need to do to keep ourselves and the people around us safe. And public health officials are worried that this could be a pretty bad flu season, as fewer people may be getting flu shots because they either don't want to be exposed out in the world or at pharmacies or for whatever reason. But so, you know, and we've made this point a bunch of times on the pod, you know, COVID is a new cause of death. And so one of the ways you can combat the impact of COVID is to reduce the other causes of death. And so, you know, getting out there, getting a flu shot, making sure people are healthy and safe, that's another way to do that. So yeah, just you can get a lot of flu shots for free at various places. Insurance also covers flu shots. So you can find all that information online. So yeah, get a flu shot.
And that's Tips for Good.
So for our second segment, we want to talk about Trump's nominee to the Supreme Court, Amy Coney Barrett. She has been going through her hearings in front of the Senate Judiciary Committee this week. They just wrapped up after 4 days of hearings. And she is the presumptive justice to fill up RBG's spot on the Supreme Court.
Yeah. So I might surprise some people in this segment in some ways. So before I say what I'm about to say, I do just want to acknowledge want to say one thing. It is absolutely essential that we do everything we can to prevent her from being appointed.
Yeah.
Now, I don't know how much we can do. Any strategies the Democrats can do, they need to do, really, because at this point, the Trump administration nominated Neil Gorsuch, which was a stolen seat that was held open for 9 months. And the whole thing was, oh, well, it's a presidential election. I mean, 9 months before the actual election itself. So that was a ridiculous situation. That was a stolen seat. And then we have Kavanaugh, who had an accusation of sexual assault. And there was this investigation that was ordered in which they refused to interview like dozens of corroborators to the sexual assault. There were several different people that accused him. So without an in-depth, thorough investigation, we nominated him to the Supreme Court. And that was completely ridiculous. And now, just a few weeks, not months, weeks before an election, they're rushing to confirm a nominee, which, you know, the standard time it takes for a nominee to be confirmed is like 70 days. So if she was confirmed before the election, it would be the shortest confirmation ever. And if it pushes past the election, I think I don't know how many lame duck nominations there have been.
Yeah.
But that definitely does not happen very often. So it is complete Republican hypocrisy to nominate her at this point. And also, they've admitted that they're specifically not focusing on a stimulus package so they can focus on this nomination. So Democrats need to do everything they can to prevent this from happening, and if they can't prevent it, they should pack the court. All of that being said, the more I research her, the more I think, meh, I mean, Trump could do worse.
Yeah.
I mean, in fact, the more I was researching her, the more I was thinking, why wasn't she nominated instead of Kavanaugh?
Yeah, Kavanaugh was a particularly weak nomination, I feel.
Yeah, that was a terrible nomination. The more I research Barrett, the more I think, like, you got a much better case to make with this one. Like, as soon as the sexual assault allegations came out with Kavanaugh, you should have had a legitimate investigation. And, if that turned up something, the nomination should have been withdrawn. And then you should have nominated Barrett. Because, like, there are some causes to be concerned. I'm not going to pretend that there aren't. Mm-hmm. But a lot of the buzz things that I've been seeing a lot of liberals and progressives post about, the more I read about them, the more I'm like, that's a little bit flimsy.
Pretty weak.
That's like, the more you research it, the weaker a lot of those arguments become.
I had some similar but not quite as conclusive results from some of my research. So one thing I want to caution us against is like Trump adjusted interpretations of Supreme Court justices. Because like Kavanaugh was a particularly weak choice. I think that we've also seen other weak choices from Republicans in the past, like Clarence Thomas. Robert Bork is another example of a really ridiculous I don't want us to like lose sight, because Republicans have often nominated these really weak candidates to the Supreme Court, lose sight of like how powerful and important and high quality nominees should be, especially for like when they're like young and nominated for life to this court. That being said, I agree there's not a lot of like hard evidence for why she would not be a good pick. I think
in normal times.
Sorry, say again?
In normal times, to be clear.
Yes. Yeah. In normal times, yeah. Yeah, obviously the procedural problems, the hypocrisy aside, specifically talking about her as a nominee. But I worry that is partially because she's only been a justice for a relatively short amount of time.
Yeah.
So she has a pretty thin record. And so I'd be very hesitant about, even as Trump, about nominating someone who has done so little adjudicating. Yeah. She spent some years working for some years clerking, early in her career, where she clerked for Antonin Scalia, among others, who was a mentor for her and informed her jurisprudence of originalism. After that, she went and worked in corporate law and private practice, and she was one of the lawyers that worked on the Bush v. Gore case, among other high-profile cases. And yes, she was on the Bush side, so the wrong side of that abomination. And then went and taught law, including civil procedure, constitutional law, and statutory interpretation at Notre Dame. And then in 2017 was appointed to the federal bench in the Seventh Circuit. So, impressive resume for sure for someone, especially someone as young as she is, but not a lot of adjudicating. And I worry that with a longer record, we would see some of her like more conservative proclivities come out. But again, to your point, like, nothing that is obviously disqualifying, for sure, especially compared to someone like Scalia, who was her mentor. Like, originalism, as problematic as it is, and I do want to talk about that a little bit, is not a disqualifying jurisprudence from becoming a Supreme Court nominee. In fact, it seems to be almost a precursor for most Republican appointments these days. Yeah.
So I want to talk about some red flags that were brought up.
Mm-hmm.
And I also want to kind of give context to some of them, because I feel like some of them lacked context.
Yeah.
So one of the ones is her association with this faith group referred to as the People of Praise, which is kind of borderline a cult.
Yeah.
I mean, if I'm being perfectly honest, like the women in leadership are literally called handmaids, which, I mean, that sounds pretty bad, you know.
Yeah.
It's this group of people that do very heavily emphasize Catholic faith, which obviously there's nothing wrong with that part, and they also emphasize like the role of a woman as subservient to their husband, and the husbands are the heads of the house. They're referred to as the heads. And like, look, again, if that's your personal belief, like, again, I wouldn't necessarily call that a red flag. I mean, I don't want us to have religious tests for people in office. I want to make sure that people are free to have their own personal religious beliefs, regardless of, whether or not they might be in one office or another. I don't want to make it sound like I'm trying to discriminate against her because of her religion. The problem
it's just
that I
crazy.
have, I mean, it's crazy, you know, and I'll make fun of it, but I won't say that she shouldn't be nominated because of it.
Yeah.
The part that concerns me is that this particular group has, at several points, advocated against the separation of church and state. However, there aren't a lot of examples of Barrett herself making that argument in an official capacity as a judge or really even as a law professor. There is one instance that came up that I think really does need context. And that was this speech that she gave in 2006 at Notre Dame Law School, in which she was talking to graduates basically about their life and their career. At one point, she said, quote, "You will always keep in mind that your legal career is but a means to an end. And as Father Jenkins told you this morning, that end is building the kingdom of God." Now, in that context, like out of context, that sounds pretty bad. Like that's it does sound like she is basically arguing that law doesn't matter. All that matters is expanding the kingdom of God. Right after that, a little bit later down, she says, keep in mind that your fundamental purpose in life is not to be a lawyer, but to know, love, and serve God. You truly will be a different kind of lawyer. So again, sounds kind of bad, but right after that, she does kind of go a little bit more in depth into that. And she uses the idea of building the kingdom of God and serving God as interchangeable terms. And she lays out 3 ways in order to live out the whole like serving God. And the 3 ways are first, praying about career choices before making them, which, I mean, there's nothing wrong with that. If you're a person of faith, it makes sense. The second one is to give 10% of your income to either a church or a charitable cause or, friends or people that need it. Like, okay, that's wonderful. I love that. Like, that's what I think most of Christianity should be, really. And then the third thing that she said was to seek out friends that share your faith. So none of those are actually about establishing theocracy and abolishing the separation of church and state. So and it was also in 2006.
Sure.
Before she was a judge. So I don't know if that's necessarily the smoking gun that people think it is.
She's also written in the past about the need to not let religious views influence judicial findings. So she wrote a law review article talking about the death penalty in capital cases specifically for Catholic judges, and Catholics as a whole reject the capital punishment. And she basically said, if you are a judge faced with a capital case and you're a Catholic, you should recuse yourself from that case so that you can avoid the conflict that would exist, which is exactly the right thing to do if you do experience a conflict with your function. So that is perfectly reasonable. I think it's pretty clear that of the potential choices for Trump to have made, she's probably far from the worst.
Yeah.
I think, the more research I do, the more that seems true.
I also want to take a second to discuss two extremely important topics that have been the primary concern of a lot of progressives, and rightfully so, and that is abortion and the Affordable Care Act. So the biggest instance that I found of Barrett straight up coming out against Roe versus Wade is there's this case where there's this thing where in 2006 she added her name to this petition or this group that opposed abortion and opposed Roe versus Wade, and to this ad that was calling for an end to laws that don't protect unborn children or whatever. But again, that was in 2006, and that was a while ago. That was before she was a judge. So, in fact, I'll admit that in 2006, I was pro-life. I mean, I was a kid at the time, and I didn't know much about the issues, but in 2006, yeah, I was pro-life, and I've changed my mind since then. Now, maybe those aren't comparable because she was an adult, but, people change. And after that, the biggest thing that I found that indicates how she might rule specifically about Roe versus Wade was about 10 years later, so about 2016, when she was talking to Jacksonville University, and she actually indicated that she didn't think that Roe was going to be overturned, but she did acknowledge that she could roll back protections for abortion. Mm-hmm. So basically what that means is rolling back how late you can do an abortion protections on how late you can do an abortion, putting more restrictions on clinics that make it harder for people to get abortions. And look, those are terrible. Those are absolutely horrible. But those aren't quite overturning Roe versus Wade. And she seems to indicate in a lot of rulings that we don't know how she would rule if given a chance to abolish Roe versus Wade. Now, there is cause for concern because Donald Trump specifically said that he wanted to appoint a judge that would overturn Roe versus Wade, so it's possible they've had conversations that we don't know about. Mm-hmm. But it's less blatant. There's less of a smoking gun on this one. Another thing with the Affordable Care Act. So the thing that people are really concerned about right now is that right now there's a Supreme Court case. It's called California versus Texas, that is trying to strike down all of the Affordable Care Act. And the arguments that they're making are so bad that even a lot of conservatives are saying, yeah, this is never going to work. So the argument is basically that, the Trump tax cuts repealed the mandate. And the way they repealed the mandate was not by striking down the specific part of the law that said you have to have insurance. It was by changing the tax, the tax punishment for not having insurance to zero. So, it's the mandate is still there in the law, but the tax is zero. So you don't. There's no punishment there's no consequence for not having insurance. So what the argument is that basically that because there is no tax, like zero is not a tax, because of that part of the law is unconstitutional. And there might be an argument to be made there. But the argument that they're trying to make is basically that because that part of the law is unconstitutional, there cannot be severability, meaning that can't be severed from the rest of the law. Therefore, the rest of it must be unconstitutional. And in order to prove that there should be severability, there has to be pretty solid proof that when Congress voted on a specific part of the law, it was voting on that part of the law with the idea that the rest of the law would also be involved. The reason why this clearly does have severability in this case is that when Congress voted to repeal that specific part of the law in the tax bill, they didn't vote on the other parts of the Affordable Care Act. So it makes no sense to use that argument to strike down the rest of the Affordable Care Act. And there was actually this mock trial, apparently, that Barrett was involved in which she actually did declare that, yeah, the zeroed out mandate, that's unconstitutional because there's no actual tax, but it still has severability. Now, she did emphasize that that doesn't necessarily mean that's how she would rule in a real case, but it does establish at least a precedent that she has indicated in some form of capacity that the specific case of in the Texas case does not have grounds to stand on. So that actually makes me feel a little bit better. But that doesn't mean that she won't be very quick to strike down other parts of the Affordable Care Act when people with better arguments come before the Supreme Court, which is why she is still a dangerous nominee.
Yeah.
But we need to be honest about how dangerous she is if we're going to be honest about how we need to stop her.
Yeah, I think that's right. I think one of the ways that she is dangerous is specifically because we can't say with any level of certainty how she will vote in or determine rule in these different cases. And that's unfortunate because, a combination of things kind of come together that leave us guessing more than knowing what kind of judge she will be. One of those things, as I already mentioned, is a relatively short career on the bench. Another is specifically through these hearings, she has refused to answer questions from the committee members specifically about these different political policies, referring back to something called the Ginsburg rule, which is basically where a nominee says that they won't rule on anything that could come before the Supreme Court while they're sitting there. So basically, most legal questions are kind of off of the table. So she did a lot of not answering those kinds of questions, which, according to precedent of previous nominees, is perfectly legitimate in many cases.
Still annoying.
Still annoying, and not legitimate in all cases. And I'll talk specifically about one of those in a minute. So we have to kind of infer her potential activity as a judge from her past, which is short, her writings, which there are some of, and kind of are mixed, and from her nomination by Trump, who is specifically trying to nominate someone who would overturn the ACA, overturn Roe, and just generally have a lot of these more conservative rulings and opinions. But again, these are all kind of guesswork. Yeah. But one thing we do know about her, which I want to talk a little bit about, is that she is an originalist and a textualist. Now, a textualist is like what Gorsuch is. And he's actually done a surprisingly less than totally crappy job so far. So that's actually not been that horrible. But an originalist is what Antonin Scalia was. And I would argue that he presided over some of the worst rulings of the Supreme Court in many, many years, and did a tremendous amount of harm to our nation and our laws and our ability to, legislate and dictate the Constitution as a living and growing document. But basically, an originalist means that she intends to interpret the Constitution in terms of its original intent and the text of the document itself. And that's kind of a regressive perspective, and not one that's aligned with more common views of jurisprudence, which focus on previous rulings and the growth of case law. That's even the longer tradition in the United States, which is a common law system where our laws weren't written down until much later on and were kind of developed based on ideas of justice and fairness. And so it's actually kind of a recent invention to think of yourself as an originalist. But the problem is that it also is not cognizant of some of the more recent developments, i.e. some of the more progressive developments in our interpretation of the laws. For example, you want women to have equal rights? Well, then you have to pass the Equal Rights Amendment, because otherwise they're not called out or necessarily included in the Constitution. We certainly know that they weren't considered as part of the 14th Amendment. And so when you're remaining internally consistent as an originalist, you don't really have the ability to say, well, of course women were meant to be included, because they clearly weren't at the time. And so it's a pretty narrow way to interpret the Constitution. And another example that I want to call out is that an originalist wouldn't have the ability to remain internally consistent and support Roe v. Wade. And this is why I say that. So one of the problems is that because you can't extrapolate to results that aren't specifically mentioned in the Constitution, she wouldn't be able to recognize a right of privacy, which was established in Griswold v. Connecticut, brought up in Roe, and is a fundamental part of a number of other rights that we recognize. Like Americans on both sides of the aisle believe in a right to privacy, and it simply doesn't exist in the Constitution. It was found. The argument that the court found persuasive in Griswold found that the right to privacy was synthesized from a number of different amendments in the Constitution. For example, the First Amendment, which is like they interpreted kind of as the right of private beliefs, and the Third Amendment, the right to have a private home against the demands of the use of soldiers, or the Fourth Amendment, which is interpreted as privacy of persons and possessions, or the Fifth Amendment, which is a person's ability to not self-incriminate, so have like personal privacy and autonomy. But ultimately, like an originalist cannot find a right of privacy in the Constitution. And as a result, she wouldn't be able to find that Roe v. Wade was supported by the Constitution. She wouldn't even be able to find that Griswold v. Connecticut was supported by the Constitution, which was a case that found that married couples could buy contraception. And so the challenge here is that what we know about her is that her judicial philosophy is an incredibly conservative one that disregards our much more common belief in the growth and the development of jurisprudence, and basically means that if she's going to stay internally consistent, which is a big if, like she has specifically said she's not going to comment on how she would rule in Roe v. Wade. She's an expert in civil procedure and legal philosophy. And so like it is very possible that she, assessing a case on its merits, would not like strike down these laws, but we know that her philosophy pushes her in her judicial philosophy, not even her religious beliefs, but her judicial philosophy pushes her towards these more conservative rulings. And she specifically said that she wouldn't comment in her hearing. She specifically said she wouldn't comment on whether Griswold v. Connecticut was rightly decided, which is crazy because while, she said she wouldn't comment on Roe v. Wade because it was a case that was actively being argued in various places. But Griswold v. Connecticut has been settled for 50 years. It is established law. If there's ever a super president, it is one of them. And she still wouldn't comment on it, which spooks me for sure. So yeah, originalism is a pretty weak jurisprudential position, and she is an originalist. And so while we don't have a lot of hard information, the information we do have, to me, points to a not necessarily disqualifying, but definitely a worrying place